there are several risk challenges that modern practices have in the AEC information space. Litigation is always a risk, not necessarily because you've done anything wrong, but as you are a practice that has insurance in place, you become a target for people who need to perhaps make money back on a project or to basically just challenge you. And you will sort of get those sort of claims against you because of a project you've worked on. And unfortunately, it can be easier to pay a claim than to defend it if you can't easily find the information, find the documentation, find all that communication that was related to a project that you worked on. The challenges at risk are also defined by the changing legal landscape. So one of the key ones for the architectural engineering space at the moment is the Building Safety Act of 2022. So I'm not a lawyer, so I won't go into too much depth. But really, the aim of the Building Safety Act is to try and gather together all of the information that was put together and discussed in the design of a building. It currently relates really to higher, taller buildings with residential in them, but I can see that becoming applicable to all projects that are built within the UK. And so you've probably heard of the golden thread, but the aim is to maintain this thread of information from the earliest stage of a project to the later stage of a project, and to ensure that the design decisions, why you chose a particular way of building something, where the structure came from, what materials you used, all that information is gathered together in one place and could be used in sort of challenges in the future. And all that information could be the formal issue of Information Act, but it could be a discussion held over email where a decision was made on what material to use, for example. The Building Safety Act had impacts on other legislation as well. So there's something called the Defective Premises Act, and that really relates to the sort of risk of litigation that follows completing a project. And again, there are different sorts of buildings that this relates to and whether they're residential or not. But really, the key thing is it's extended from what was 6 years after the date of completion of work up to 15 years, the time range that people can basically sue you or involve you in litigation regarding a project. Apparently, where the claim relates to construction rather than refurbishment, there's now a 30-year retrospective liability period. So that means in 30 years' time, you're might need to be able to bring together the documentation about how you were involved in a project, the information you created, the design decisions you made, and be able to basically take those to court as evidence. So 30 years is a long time. And I was thinking back to what my computer looked like in 30 years ago. We're basically talking about your Windows 95 PC and maybe Office 95. So 30 years ago is a long time. Did the applications you have 30 years ago even exist now to read those documents and to produce, if you can even find the information that you created 30 years ago, can you read it? And makes me think maybe paper was easier. All those boxes or archives of records that you've got stored away in a warehouse somewhere aren't particularly accessible, but at least you've got an index so you can go and find that information. So moving to this digital way, we should be able to hopefully address that challenge in the risk area. One of the questions we often get here asked are, if we're using a common data environment, does that help with some of these challenges that you just went through? So a common data environment is something primarily or normally provided by the lead contractor on the project. And it's a secure location to upload, store and share information related to a project. And so maybe that helps. If you've got a place to store all this information, do you need to worry about the things I just went through? So I would argue no, the problem is it's not your common data environment. And so I did some research and there's lots of information on the web about this. But basically, one of the biggest risks that you have is when the relationship breaks down in a contractual arrangement where you might be involved in, the party that controls the common data environment may withdraw your access to it. And that's quite a good tactic legally. If all the information that you need to challenge a claim against somebody is in their system, then the obvious thing for them to do is withdraw your access from it so that you can't have access to that information again. And so this has actually happened in real life. There are quite a few cases on the web that you can find where a lead in a project has withdrawn access to the information that people needed to defend their own claim. So a common data environment is great while the project's running, but really you need a copy of all your own information independent of what the project lead provides to you.